Welcome to today's program titled Midsummer New Jersey Employment Law Update. At this time, all participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A box located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Howie Wexler. Howie, you may begin.
Thank you very much. I appreciate it. Can we go to the first slide, please? Thank you, everybody, for joining us here today for our Midsummer New Jersey Employment Law Update. It still is early August, so I still think it is midsummer. At least I'm hoping to cling to that. Although for some, we've had our interns that have left us, so for them it's the end of the summer. Camps are ending soon, so but for me, I'm still clinging to this is the middle of the summer. So we hope everyone's safe and doing well. And thank you for joining us here today. We're going to be going over a variety of topics regarding certain issues that we just want to highlight to make sure that everyone's aware of, some more pressing than others, but we think this is a good time to catch up with everyone as we gear up for the fall. Obviously, when we even planned this, the Delta variant wasn't where it is now. So I know COVID issues, which everyone was hoping was kind of in the rear view mirror, is coming back. But these other issues under New Jersey law that are relevant for employers, we want to highlight for you as well today. Want to take some time to introduce my fellow panelists. Although from their pictures, they've all grown impressive COVID-related beards, which I held out and refused to do, although we still have some time left for the presentation, so we'll see. First is Rob Sibba. Rob is a partner in Seyfarth's Labor and Employment Department and represents employers in a variety of industries, including retail, banking, entertainment, background check services, food service and hospitality, transportation, and public works. Rob advises employers on a variety of issues under federal, state, and local law, including background check, Fair Credit Reporting Act violations, ban the box laws, prevailing wage requirements, wage and hour and overtime compliance, whistleblower retaliation, FMLA compliance, paid sick leave, and a wide range of discrimination, harassment, and retaliation issues. Rob handles complex employment litigation, including class, collective, and multi-district litigation, as well as single plaintiff lawsuits. Next is Ephraim Pierre. Ephraim's a senior associate in Seyfarth's new Labor and Employment Department and a member of our New Jersey practice group. He represents employers in complex employment litigation throughout the country, including class collectives, arbitrations, and single plaintiff lawsuits in New Jersey state and federal court. In addition to litigation, Ephraim regularly advises employers on a wide range of employment issues under federal, state, and local laws, including background check and FCRA issues, internal investigations, disability accommodations, diversity inclusion programs, and FINRA broker-dealer regulations. Our next panelist, Dan Small. Daniel's an associate in our New Jersey practice group. He represents employers in single plaintiff, multi-plaintiff, as well as class and collective action litigation, and he defends management against claims of discrimination, harassment, retaliation, unpaid overtime in federal state courts in New York, New Jersey, as well as Pennsylvania. He also represents employers in federal and state investigations regarding claims of discrimination, as well as audits concerning employee misclassification issues. Daniel's advisory practice includes COVID and other workplace safety considerations and religious accommodation laws, wage and hour compliance, misclassification, employee handbook review, layoffs, and termination guidance. And finally, I'm Howie Wexler. I'm a partner at Seyfarth and co-chair of our New Jersey practice group. I represent employers in single and multi-plaintiff discrimination cases, as well as wage and hour matters. As part of my traditional labor law practice, I represent employers in election proceedings, as well as serve as chief negotiator at the table in union negotiations. And I represent clients across all industries with the focus on transportation and logistics, telecommunications, and hospitality. We're all happy to be with you here today and look forward to a good presentation. There is the Q&A function, so if you do have questions that arise during today's presentation, please don't hesitate to type them in. We have reserved time at the end of the presentation to try to answer as many of those questions as we can. And to the extent we're not able to answer those today, we get a printout of the Q&A, so we'll be certain to respond to everyone at the end of the presentation or afterwards. Next slide. Here's our agenda for today. We're going to start off talking about disability accommodation issues under New Jersey state law. There's an important Supreme Court case that recently came down, which we're going to use as kind of our launching off point for this discussion, as well as go over some best practices. Even pre-COVID, accommodation issues were always complex and stymied employers, given the unique nature and the kind of no one size fits all approach, and that can remain the same throughout. Next, we're going to talk about arbitration agreements in the employment context. This is and always remains a hot button issue. Under New Jersey state law, there have been some changes, and then there's since been some decisions interpreting some of these laws that we're going to spend some time talking through today. Next, we're going to go over New Jersey's crackdown against independent contractor misclassification. This is a topic that we've covered, I think, for the last 2 or 3 New Jersey-based webinars that we've held, and the reason being that each time there's been something new to report on, and this presentation is the same. This has been a focus of Governor Murphy. New Jersey was a little late to the party as opposed to New York and some other states that have gone after misclassification issues for quite some time, but New Jersey's making up for lost time by being fairly aggressive in coming out with new laws following a task force that Governor Murphy initiated pretty soon after he took office. And then finally, our 2-minute warning. There's some topics that we've spoken about in the past at our presentations, which kind of remain alive and well. Some have been delayed, their implementation because of COVID. So we, again, just want to highlight these for everybody so that they're on your radar and make sure it's something that you're thinking about, although some of the issues are kind of still not effective yet, but things that we envision once the legislature and government start dealing with non-COVID related issues, we expect to be, among the first few things that employers start having to deal with. So, and then finally our Q&A session. So with that, I'm going to go to the next slide, and we're going to kick things off with Ephraim talking about disability accommodations under New Jersey's law against discrimination.
Thank you, Howie, for that detailed introduction. And as he stated earlier in our presentation, I will be discussing with you disability accommodations under New Jersey's law against discrimination, or the LAD. You can move to the next slide, please. The LAD is one of the oldest anti-discrimination statutes in the nation. In fact, the LAD covered individuals with disabilities as late as 1972. Like the ADA, the LAD protects qualified individuals with known and perceived disabilities from discrimination. Under the LAD, employers are required to provide reasonable accommodations for disabled individuals unless that accommodation would impose an undue hardship. Hardships are largely determined on a case-by-case basis. A growing theory of liability under the LAD has been failure to accommodate claims. This is generally where a disabled employee claims that an employer failed to make a requested change to the terms and conditions of their employment that would otherwise permit them to complete the essential job duties of their position. You can move to the next slide. Prior to 2021, to prove a case of failure to accommodate under the LAD, a plaintiff would have to establish in some way or fashion that they suffered an adverse employment action, such as a demotion, a termination, or a material change in their terms and conditions of employment. However, this all changed on June 8th, 2021, when the New Jersey Supreme Court lowered the threshold for failure to accommodate claims by holding that an adverse employment action was unnecessary to sustain that claim. Now, while the facts of this case are relatively straightforward, they are important to understanding the reasoning of the court and some of the key employer takeaways here. So I'm just going to briefly review some of the key facts which are before you on the slide. The case that we're talking about here today is Richter v. Oakland Board of Education. In this particular case, the plaintiff was a science teacher employed by the school district. She was assigned to a Valley Middle School. She was a science teacher who had a pre-existing health condition, type 1 diabetes. At the start of the academic term, in the 2012-2013 year, the plaintiff was given a later than normal lunch period. This was a concern to the plaintiff because she believed that her blood sugar would drop to an unhealthy level if she took her lunch break far too late in the day. As a result, she made a accommodation request. She asked the principal of the middle school to move up her lunch period to earlier in the day. The principal claimed that he would look into it, but no schedule changes were ultimately made for the plaintiff in the first marking period. During this time, she took glucose tablets in order to keep her blood sugar level. And in the second marking period, she was given an earlier lunch period that allowed her to better manage her blood sugar levels. This unfortunately changed in the third marking period. When the plaintiff received her schedule, she notified the principal of her prior request and again requested an earlier lunch period to avoid any issues with her blood sugar dropping. Again, the principal claimed that he would look into it, but ultimately denied the requested accommodation and instead asked the plaintiff to either sit down, eat a snack, or simply sit out of her required cafeteria duties before her lunch period. The plaintiff asked for this guidance in writing, but didn't receive it. Given that she was not given any alternatives, she attempted to work through her required lunch periods and instructional periods. Later, in March of 2013, the plaintiff passed out at work and sustained some pretty serious injuries while in front of her students. As a result, the plaintiff went out on temporary disability and then later brought claims against the Board of Education here, first for work-related injuries that was paid out through workers' compensation benefits, and then later she brought a failure to accommodate claim under the LAD. You can move to the next slide. Now, the parties wrangled over several key legal issues in this case, and here we're going to focus on one, which is the accommodation issue. Below and before the New Jersey Supreme Court, the parties argued whether or not a adverse employment action was required to sustain the plaintiff's claims here. The defendants before the New Jersey Supreme Court argued that a prima facie case of failure to accommodate required that the plaintiff here plead an adverse employment action. And the strength of their argument was that nothing of the sort happened to the plaintiff here. She was neither terminated or demoted, received no reduction in pay or change in job duties. The plaintiff argued just the opposite, that an adverse employment action was not needed. This was a point of ambiguity in the law for the LAD, and the court ultimately began its analysis of this issue by surveying the requirements for this claim in both state and federal courts. Two prior decisions really drove the court's decision, in particular, State v. Victor. In dicta in that case, the court noted that the LAD may allow plaintiffs to bring a failure to accommodate claim against an employer who ultimately failed to engage in the interactive process, but nonetheless did not take any adverse employment action. This was in dicta because in that case, there was an adverse employment action, so the court did not need to reach this question. Later, in another case, Royster v. State Police, the court recited the elements for a failure to accommodate claim and did not include an adverse employment action. But again, this ultimately didn't sway the day because there was an adverse employment action that was there. The court also surveyed federal courts interpreting the ADA, which is a common analytical process for New Jersey state courts when interpreting the LAD. And there they found several cases where an adverse employment action was deemed to be unnecessary or where refusing to make a reasonable accommodation was sufficient enough to sustain the claim. Based on this growing ambiguity or silence in many cases in these matters, the court decided to rely on the broad legislative intent of the LAD, which is to eradicate workplace discrimination. And in doing so, they held that an adverse employment action was not a necessary component of a failure to accommodate claim. Now, in reaching this determination, the court determined that It determined that the defendant's failure to provide the plaintiff with an accommodation for her diabetic condition was sufficient to sustain her claim. Important here for the court was that the wrongful act was the failure to accommodate the claim, the accommodation request, which was the duty of the employer under the LAD. The court reasoned that requiring an adverse employment action would allow an employer to ultimately escape liability by simply refusing to accommodate an employee while not taking any adverse employment action. This obviously leads to a potential situation where a plaintiff may be forced to suffer or make changes to their treatments or their or medical condition while their accommodation hasn't been granted. In this particular case, the plaintiff took glucose tablets and other means in order to keep her blood sugar level at a particular level. So accordingly, the court held that an employer's inaction, silence, or inadequate response to a reasonable accommodation request is an omission that can give rise to a cause of action under the LAD, which is different than an act of commission where you do have an adverse employment action. You can go to the next slide, please. The key phrase from the Richter decision on the issue of reasonable accommodations is the court's holding that an employer's inaction, silence, or inadequate response to a reasonable accommodation request gives rise to a claim. Now, they resolved this ambiguity, but it raised new questions potentially in the language that it uses. While a potential defense was eliminated to an accommodation request where a plaintiff doesn't plead an adverse employment action, the court did not precisely define what would constitute an inadequate response to an accommodation request. One could assume that obviously the response in this particular case concerned the court, and one could term that as an inadequate response. But by leaving this issue open, the onus is certainly on employers to engage in a proactive, interactive process. Employers should be prepared to explain the reasoning behind their actions when responding to an employee's request for an accommodation, and also show a response in a timely manner. Now, the Richter decision continues a trend of the New Jersey Supreme Court in pursuing the full extent of the LAD's legislative intent. We've seen that in other cases in this recent 2021 term, which we'll address in later portions of today's presentation. But it's clear that the Supreme Court is certainly interpreting the LAD to provide further protections for employees and is ultimately shifting the onus to employers to make certain responses to certain claims. You can go to the next slide. While the Richter case in of itself may have been a rather straightforward accommodation request, in the end, the plaintiff here merely asked for an earlier lunch period to accommodate a pre-existing diabetic condition. However, the accommodation landscape is rapidly changing for employers, and it's one where employers need to be particularly vigilant and ensure that their practices, policies, and procedures are properly considering many accommodation requests that they're receiving that may be of a new variety. In terms of an undue hardship, the growth in remote work and telecommuting capabilities certainly removes some of the pre-existing undue hardship arguments relating to those workplace arrangements. In the past, many employers had stated that it would be too difficult to have certain employees manage or otherwise participate in their workplace duties from home or telecommute or in remote work. Obviously, COVID-19 in the past 18 to 19 months now has certainly proved that not to be the case for several industries. So this might be an arrow that might be removed from the potential defenses for employers. Additionally, COVID itself will seemingly create new requests for accommodations for those who have suffered and convalesced after contracting COVID. In particular, in July of this year, President Biden commented that those experiencing long-term effects from COVID may qualify for disability protections. Some of the long COVID-19 symptoms or effects that some people may experience include the loss of smell or taste, depression or anxiety, memory or concentration or sleep problems. It's been categorized as COVID fog, or blood clotting issues. Any one of these issues can potentially trigger an accommodation request from an employee. An employee may request a particular change in screen or workplace layout if they're experiencing issues as it relates to concentration or their vision. Plotting issues may require employees to perhaps not sit or stand or lift particular items. An increase in depression or anxiety may require them to take intermittent treatment for mental health. All these things, all of these potential requests, again, are changing the landscape that employers may need to address. Another thing to always keep in mind as well is a growing focus on mental health within the workplace and within the personal lives of individuals during these past months. Explicitly, the LAD includes mental health conditions such as depression, anxiety, adjustment disorders, and PTSD. Therefore, if an employer is faced with an accommodation request that is primarily based upon a person's mental health for any of these or numerous other conditions, that interactive process is still required and should not be shrugged off. The employer should certainly keep in mind requests where the basis of which includes mental health. In addition, the legalized use of marijuana under new statutes under New Jersey law is also changing the accommodation landscape as well. Just recently this year, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act, certainly is a mouthful, came into enactment this year. And prior to that, the Jake Honig Compassionate Use Medical Cannabis Act as well has been both enacted many years ago and has been litigated. And while the use of marijuana in the workplace is not an accommodation that employers need to necessarily make, these employees, however, may request accommodations surrounding perhaps medical treatment that involves the use of cannabis outside of work. So it's particularly important that employers keep their ears to the ground in terms of the types of requests and conditions that are essentially growing that may affect employees in the workplace. You can go to the next slide, please. So, in this changing dynamic with new capabilities from employers growing in their prevalence and also new conditions, what are the best practices? Well, first and foremost, engaging in an interactive dialogue that's transparent and timely is certainly the best practice here. That's certainly something that was not necessarily displayed in the Richter facts and decisions, right? So maintaining a clear accommodation policy is key. Further, training managers on how to identify accommodation requests and where to direct them is also key. In many of our cases, we find that the communication breakdown ultimately happens where a manager, or I shouldn't say ultimately, but quite frequently happens, where a manager just simply does not direct the request to the right place and only assumes that the accommodation or interactive process is ongoing. So it's important to train and equip managers to identify these requests and get it into the hands of the proper human resources or employee relations personnel. Another key issue here is timely response. Responses should be made in a reasonable amount of time and shouldn't be made to languish. Given the change in the law under Richter, that amount of time once a request is made essentially triggers a potential claim at this point. You don't need to wait until this request is necessarily directly rejected or any type of adverse employment action is made. It's the failure to engage in that interactive process to provide that accommodation that's going to trigger the claim here in this case. So timely responses should be emphasized. In addition, an interactive dialogue with employees must include a wholesome discussion of what's at issue here. So that includes the accommodation needs of that employee, the potential accommodations or alternatives. Employers should be prepared to discuss not only the accommodation that the employee suggested, but also alternatives that may be better suited for both the workplace and the employer, but while also being mindful of the needs and requests of the employee. Also, the undue burden of a proposed accommodation. It's important to enunciate those to the employee. So again, the process is transparent. In ending the process, the interactive process, you can either obviously grant a reasonable accommodation or give a clear conclusion that the reasonable accommodation can't be made without an undue hardship. B, an alternative was offered but ultimately rejected by the employer, or C, no accommodation exists that will simply allow the individual to perform their essential tasks. So it's particularly important that this process is followed, and it's advisable for employers to look over their process map this process, figure out where the pinch points are, where information might not be flowing, and identify where perhaps documentation may be lacking or where the process can be improved, given that we're looking at a lower threshold here. There you go. And that will conclude my section here of the presentation. And I believe I'll be passing it over to Rob.
Ephraim, thanks so much. Very insightful comments and really interesting on this really cutting edge area of New Jersey law. Let's take a look at the next slide, please. Keeping with the theme of LAD legal developments, let's take a look at a recent case that bears a particular bit of attention for our purposes today. Over the years, as we've seen the changes that we have socially, that has really impacted our views on discrimination, harassment, hostile work environment, and such claims. In a recent case, Rios versus Meta Pharmaceuticals put that issue front and center for us at the New Jersey Supreme Court. The case was decided a little bit over a month ago, about 6 weeks ago, and it really dealt with the dynamic of a supervisor who had made 2 comments in the workplace that were central to the claim. So let's take a quick little step back and talk about what actually happened in this case. So the plaintiff was a Hispanic male who was hired as a director of brand marketing at Meta Pharmaceuticals. About a month after he was hired, he was talking with his supervisor, and he was saying that he and his wife were looking for a new home. And allegedly, the supervisor responded, and pardon my language, this is for purposes of education, but the supervisor replied, "It must be hard for a SPIC to get an FHA loan." That didn't really sit well with the plaintiff, but he kept on working without incident for some time later, at which point he was with the supervisor again, and they were working on a marketing campaign casting actresses for a television commercial. And allegedly, the supervisor turned to him at one point and motioned to one of the actresses and said that she would work, except that if she didn't look so spicky. So that didn't sit well with the plaintiff either, but he continued working. A few months later, he was put on a performance evaluation plan. He started getting negative reviews. He had made some HR complaints a while back, but they kind of got brushed off. And ultimately, his employment was terminated for poor performance. He sued on the basis that his supervisor, by making those 2 comments, had created a hostile work environment. And the case law over the decades that we've seen these cases develop has really looked at the severe or pervasive analysis, whether circumstances of employment were severe or pervasive, and did that rise to the level of a hostile work environment. So the court explained in analyzing what had happened here that claims must be evaluated in light of all the circumstances of employment. So that includes the frequency of whatever conduct is alleged, the severity, whether there is any physical threat or humiliation element, or whether it's simply an offensive utterance, as well as whether the conduct at issue unreasonably interferes with the employee's work performance. So in analyzing this context and this set of facts, the court made 2 noteworthy comments. The first comment was that severity, when you're analyzing that prong, can be exacerbated when it is uttered by a supervisor, because supervisors have an important role in shaping the workplace. So what that means is when the conduct is engaged in by an employee's direct supervisor, that takes on basically an additional element of severity. And here, the two comments that were made by the supervisor. And because they were made by the supervisor, they ratcheted up in severity level from the court's perspective. The other notable comment that the court made is that the perspective of a reasonable person in the plaintiff's position is what we have to look at the conduct through that lens, and that this view should take into account the sensibilities of our present-day society. So effectively what that means is when we're looking at case law from 10, 15, 20, 30 plus years ago, those sensibilities may have changed. And as we've seen over the past year, 2, 3, 4, the sensibilities of our society have changed dramatically in certain ways. And because of that, today's hostile work environment and today's set of facts alleging a hostile work environment can result in a markedly different analysis, because we've seen cases over the years that included one comment, a racial slur, for example, like in Taylor v. Metzger from many years ago, that was not held to be a hostile work environment. And effectively it was said, well, it was just one comment that was made in passing. It wasn't really a hostile work environment if it was just said once. Here, it was two comments. The takeaway is not so much that this establishes a bright line rule of two comments versus one comment, but it does kind of remind us to view these types of claims from our present day society and whether the conduct that's complained of crosses the line of our sensibilities into a hostile work environment. So this is a very important case, that really builds on the case law in this area, and certainly something that we should be, have on our minds kind of going forward with analyzing hostile work environment claims. Next slide, please. Let's take a look at our next topic, a bit of a topic, arbitration agreements in the employment context. Now, over the years, we've seen a lot of case law developments. We've seen a lot of fluctuation. We've seen a lot of push and pull at both the state level, the federal level, decisions that have really created a pretty robust body of case law on arbitration agreements in the employment context. In about 2019, largely in response to the Me Too movement, there was a law that was passed that's affectionately known as S-121, referring to its Senate bill number at the time. One of the components of S-121 was, it included a provision that's listed here in the PowerPoint that would basically, the text was that any provision of an employment contract that waives any substantive or procedural right or remedy relating to a claim of discrimination, retaliation, or harassment shall be deemed against public policy and unenforceable. Now, a little backstory here, the provision in question was drafted by Loretta Weinberg and her office out of Bergen County, and involved significant input from the plaintiffs' bar, including attorneys who had worked on some of the cases that we heard about during the Me Too movement, some of the most prominent cases there. They were sensitive to the fact that if they targeted arbitration specifically, that may run afoul of federal law, such as the Federal Arbitration Act and its preemptive power, and intentionally created a broad prohibition. That's why we see the language of any substantive or procedural right. The explanation at the time was that the clause was meant to target not just arbitration agreements, but also agreements to waive jury trials, agreements to shorten statute of limitations, and any other such procedural nuances that could be addressed by contract. That issue was litigated for the first time in a case called Janko versus Bay Ridge Automotive, and that was out of Monmouth County. This is just a trial court decision. This is, to my knowledge, not been appealed, and I'm not aware of any appeal that's currently before the appellate division that would take this head on for review. But effectively, what the court found in Janko on a motion to compel arbitration was that the FAA, Federal Arbitration Act, preempted state law because it discriminated on its face against arbitration and or covertly try to accomplish the same objective by disfavoring contracts that have the same defining features as arbitration. So for example, things that here we have the procedural right or remedy that relates to discrimination, retaliation, or harassment. So effectively, state law and S-121 was not reconcilable with the national policy, as well as New Jersey policy, that favors arbitration as a form of dispute resolution. So Monmouth County was the first state court decision that basically invalidated S-121's ban on arbitration provisions as they related to discrimination, retaliation, and harassment. Now, notably, S-121's reach only covered those areas of employment claims. So theoretically, claims of, let's say, relating to leave, terms and conditions of employment, such as wages and hours, or any other such non-discriminatory or retaliatory or hostile work environment type claims, survived nonetheless. So arbitration agreements were not dead in New Jersey. It was just a subset. But nonetheless, in Janko, the state court invalidated that. Next slide, please. In March of 2021, Judge Thompson at the district court addressed the same issue and relied on the Janko decision for some assistance. But the Grewal decision, this was a declaratory judgment that the U.S. Chamber of Commerce had sought starting back in August of 2019. Notably for the civil procedure folks on the webinar today, one of the first issues that was actually of interest was whether the organization had standing to enjoin the New Jersey Attorney General's office, and the federal court found that indeed there was standing and they could proceed. Again, the federal court cited the U.S. Supreme Court's decision in Kindred and pointed out that any state law that discriminates on its face or tries to get at the same objective covertly of disfavoring contracts that have the same defining features as arbitration would be preempted by the FAA. So now we have both a state court and a federal court decision that not only invalidated S-121, but really reaffirmed the state and federal level judiciary's commitment to enforcing arbitration agreements. So next slide, please. Let's take a look at where we stand in terms of arbitration in New Jersey. Over the years, there have been some significant cases in the area, and we'll go through a couple of them just to level set and remind everyone on what are the hallmarks of enforceable arbitration agreements in New Jersey. So cases, for example, like Martindale versus Sandvik from the New Jersey Supreme Court about, well, now it's, I guess, close to 20 years ago, included a clause that where the employee had agreed to waive her right to a jury trial and that all disputes relating to her employment shall be decided by an arbitrator. The arbitration agreement was clear and unambiguous and was sufficiently broad to encompass all of the plaintiff's claims. That arbitration clause was upheld. In Griffin versus Burlington Volkswagen, the clause contained language saying that by agreeing to arbitration, the parties understand and agree that they are waiving the right to maintain other available dispute resolution processes, such as court action or administrative proceeding, to settle their disputes. And again, that was upheld. In Curtis versus Selco partnership, the clause on the next slide stated, instead of suing in court, we agree to settle disputes only by arbitration. The rules in arbitration are different. There's no judge or jury, and review is limited, but an arbitrator can award the same damages and relief effectively as a court would. This was deemed to be sufficiently clear, unambiguously worded, and created a satisfactory distinction from the agreement terms and drawn in suitably broad language to provide a consumer with reasonable notice of the requirement to arbitrate. So this body of case law, and let's go to the next slide, please. This body of case law really related to a case in 2014 that laid out the parameters of what an enforceable provision would be. And that case was called Adelise versus U.S. Legal Services. in Adelise, effectively, what the Supreme Court had said was that in order to be enforceable, a waiver of a jury trial and a waiver of going to court would have to be clearly and unmistakably established. There was a heavy emphasis on the clarity of what the parties were agreeing to and what the differences between arbitration and litigation would be. The court pointed out that there was no quote unquote magic language that the parties would need to invoke, but the parties did need to make that agreement clear. So let's take a look at what happened in Adelise for a second. And in Adelise, the arbitration provision was invalidated because it wasn't sufficiently clear. They talked about binding arbitration, but there was no explanation as to the fact that the person was giving up the right to sue in court. There was no explanation of how arbitration was different. It was not written in plain language, and it was not clear and understandable to the average person, and it did not really cite what anybody was waiving. And in terms of the employment context, we see here at the bottom of the slide, the important distinction that a lot of courts in New Jersey have held is that there is a difference between claims arising out of the employment relationship and the termination of the employment relationship. And that reference to claims arising out of employment and or its termination is a very critical component of any New Jersey arbitration agreement. So what have we learned from Adelise? Next slide, please. Subsequent to Adelise, we've had multiple challenges to various arbitration provisions, such as Kernahan versus home warranty. Here we saw an agreement that where the phrasing was, any and all disputes, claims, and causes of action shall be resolved exclusively by the American Arbitration Association in the state of New Jersey under its commercial mediation rules. Now, those following along, you heard me say a lot of things that didn't really jive. And the court picked up on that. It said this was not an enforceable arbitration clause because this appeared in the section of the agreement that was labeled mediation. And the court pointed out that mediation and arbitration are two completely different things. One is effectively a litigated form of dispute resolution. The other one is a form of getting the parties to agree through a confidential process to their own resolution. That did not have the sufficient level of clarity to apprise an employee or a person of what the differences might be. The provision was in a small font, and it was confusing in how it was structured, and the reference to the commercial mediation rules exacerbated that confusion. This arbitration provision was deemed unenforceable. The next slide, please. Versus Pfizer. This was a very interesting case because we had an employee that had already been working for 4 years when the company rolled out the arbitration policy. And the policy effectively, part of it was, if you continue working beyond 60 days, you'll have deemed to agree to the terms of this policy. The plaintiff didn't really take any other action, continued working. Sometime later had a dispute, and there was, litigation over the enforceability of the arbitration clause. Extremely important point here. Continued employment can be an expression of agreement. The courts in this area have disagreed over the years, but effectively where we've landed from the New Jersey Supreme Court is that if an agreement provides for a certain method of accepting a contract, for example, signed on the dotted line, click through on the internet to show your agreement, or continue working beyond the 60th day from today, the court will accept those actions if they're laid out in the agreement as an expression of assent to the terms. There was further challenges that the arbitration provision was not communicated sufficiently because it was sent by email, and people are flooded by emails. Who was paying attention to email? The court said that there's no basis in the law to say that something communicated by email cannot be enforceable. It's 2021. It would fly in the face of where we are as a society to say that there's too many emails, so nothing can be enforced via email. There was also a dispute over terms of the policy being communicated through training programs, etc. And the court basically said that there may have been a better method to doing this, but that doesn't mean that this agreement is not unenforceable. It was sufficiently clear and sufficiently communicated, and the terms were enforced. And let's take a look at the next slide for one of our last cases for some further learning lessons, Flansman versus Jenny Craig. The challenge here was that the arbitration clause did not really contain a tremendous amount of detail as to how arbitration would proceed. There was no forum selection clause, there was no choice of law provision, and there was a dispute whether New Jersey or California law governed. The employee challenged that, saying it was unfair and unconscionable to have this ambiguous set of rules that nobody really knew how to follow. And the court pointed out that it's not just the federal policy that favors arbitration, the state policy favors it as well. Perhaps not the plaintiff's bar, but overall the state supports arbitration agreements between parties and engaging in private dispute resolution. And because of that, the court invoked not just the FAA, but the New Jersey Arbitration Act and said, the law already provides a default set of rules. If the parties don't have an agreement contrary and need to utilize the process, a court is going to appoint an arbitrator on application of the parties, and that arbitrator has a basic framework within the law on how to conduct conferences, evidentiary determinations, summary disposition of claims, how to conduct hearings, and it authorizes the court to replace a designated arbitrator who ceases or is unable to act. So there's a catch-all provision where there is a process that the parties can follow by default. So what we've learned from the past couple of years of looking at arbitration decisions is that indeed the courts are willing to enforce arbitration agreements. They are committed to the policy supporting arbitration, and the attempts to invalidate arbitration in a specific area by virtue of challenging the fact that there's an arbitration agreement to begin with runs afoul of both federal and state law that's supportive and construes strictly any such prohibitions. So the takeaway, arbitration agreements, viable in New Jersey. There are a number of rules and best practices on how to craft an enforceable arbitration agreement. And doing so, for the right parties, for the right situation, can be a very effective way of addressing any disputes. And with that, if there are any questions, I'm happy to address them. You can comment or ask questions in the WebEx functions or reach out directly. With that, I will turn it over to Daniel to talk about another cutting edge issue on independent contractors and misclassification. Take it away, Daniel, and thanks so much.
All right, thank you, Rob. Appreciate it. So with this last full-length segment here, as Rob mentioned, want to address New Jersey's crackdown on independent contractor misclassification. As you see on the next slide, that this has been a priority, as Howie mentioned, a big priority of the Murphy administration since the beginning. Since this term began in January 2018, Governor Murphy has created a misclassification task force and pursued and signed several pieces of progressive legislation. What I'd like to do is sort of break down what the task force accomplished and how that laid the groundwork for the legislation that came out in 2020 and has come out now just about a month or so ago in 2021. So in the next slide, we'll begin discussing with the Misclassification Task Force. In May 2018, which was just a few months into his administration, Governor Murphy issued an executive order establishing a Misclassification Task Force to, quote, promote fairness, fight against discrimination, and to work to end unfair labor practices that create an unfair advantage over companies that play by the rules and hurt our working families. The task force issued a report in July 2019 in which it issued both general and the legislative recommendations. Just to briefly review the general recommendations, and I want to go over these because you'll sort of hear them repeated in some of the ultimate legislation efforts that came to fruition. Those general recommendations were to target education and public outreach by creating a hotline, webpage, and email address to report misclassification for the public, and to raise public awareness through a press strategy, to strengthen state contracting requirements by having state contractors affirm that they are aware of the New Jersey's version of the legal standard for proper classification of workers, to increase interagency coordinated enforcement and data sharing, cooperation with neighboring states in investigations and also training, referring potential criminal violations to the Office of Attorney General for prosecution, and then finally to remind the DOL, the Commissioner of the New Jersey's Department of Labor, he should be able to use his power to revoke or suspend licenses to deter employers from not complying with labor laws. So with that, I want to talk about what you see before you on the slide, which is the specific legislative recommendations that came out from that task force when they issued the report, again, in July 2019. The report advocated that there should be legislation that, number one, requires public posting of notices regarding misclassification. Number two, gives the Department of Labor the ability to issue stop work orders. We'll speak about that one in depth. Number three, grants the Department of Labor the same access to tax information as other cabinet agencies, for example, like the Treasury Department. Number four, imposes liability on employers who rely on companies that misclassify their workforce in their supply chain, in subcontracts or other contracts where a joint employment relationship is established. Number five, imposes liability on business owners and successor entities that misclassify their workers. Six, requires companies found to misclassify their workers to fund investigatory costs and any attorney's fees incurred. And then finally, increases fines and penalties for non-compliant companies. So that, again, was all of the recommendations that came out of the Misclassification Task Force's report that they issued in July 2019. So turning to the next slide, we begin to see what legislation came about from that task force. Again, within a year, you're already seeing the priorities being rolled out here in the Democratic-controlled state legislature, along with Governor Murphy's blessing. So in 2020, as I mentioned, Governor Murphy signed a slew of legislation that was designed to tackle what his administration perceived to be rampant worker misclassification in New Jersey. Particularly, these laws permitted the Department of Labor's and Workforce Development to issue stop work orders to employers who misclassify their workers. Number two, permit the LWD, this is the relevant section of the Department of Labor, to issue penalties for worker misclassification. Number three, require employers to post notices for employees regarding worker misclassification and to notify them of their rights. Number four, impose joint tax liability on contractors who supply employers with workers deemed to be misclassified as independent contractors. Five, permit the LWD to post information publicly concerning a person or business who violates misclassification laws. And then six, to permit the Department of Treasury to share tax data with the Department of Labor for purposes of enforcing wage and worker misclassification. Now, all of these sort of bear discussion and have increase the arsenal that the LWD has to enforce misclassification. But on the next two slides I'd like to do is just to address the first two in particular. So on the next slide, I wanted to talk about this first piece of legislation, of the legislative package that Governor Murphy again signed in 2020. So as I mentioned, this law permits the LWD to issue stop work orders to employers found to be in non-compliant with the state's various wage laws, including misclassification. The LWD, to issue a stop work order, the law requires that the LWD first has to conduct an appropriate audit or investigation, and after doing so, determine that the employer is in fact in violation of its wage and classification obligation. The law requires the LWD to first provide an employer at least 7 days notice of its intent to actually issue the stop work order, which again can only be issued after it conducts an appropriate audit or investigation. The employer is not without any recourse, however. Under the law, the employer who's found to have been in violation by the LWD is entitled to seek injunctive relief from a court if it can, quote, demonstrate that the stop work order would be issued or has been issued in error. Obviously, that's a little bit of a burden for an employer to prove. Finally, and relatedly, the law also allows the LWD to issue subpoenas for witnesses and documents relevant for the purposes of enforcing such laws, including in the context of the audit or investigation that they have to conduct. So that was sort of a new step and a significant one in the toolbox for the LWD in enforcing misclassification. On the next slide is the second piece I want to talk about, which is the increased penalties that the law provided for the LWD to levy against employers that they deem to have been in violation of various misclassification laws. So there are two penalties that the LWD now has the right to issue against a employer, again, that they find to be in violation of these misclassification laws. The first one is what's dubbed an administrative misclassification penalty. This is collected by the LWD and also kept by the LWD. As you can see on the slide, it provides a penalty up to a maximum of $250 per misclassified employee for a first-time violation, and a maximum up to $1,000 per misclassified employee for each subsequent violation. So obviously, you take each misclassified employee and multiply that by the total number, these dollar figures can add up, certainly. The second penalty that the LWD can levy against an employer is to be passed on to each of the misclassified workers. And that's calculated based on, it cannot be more than 5% of each misclassified worker's respective gross earnings during the prior 12 months. So there is some limit there, but certainly depending on the respective, each worker's gross earnings, that could vary significantly. Those penalties, the law provides that there's a series of factors that the LWD has to consider when assessing and issuing a penalty. And those are, number one, the history of previous violations by the employer, the seriousness of the violation, the good faith of the employer to comply with laws, and fourth, and finally, the size of the employer's business. So the LWD has to take all that into account when deciding on the size of that administrative penalty, that first penalty we discussed. The law further provides that these penalties cannot be levied until the LWD provides, one, notice to the employer of the violation and the amount of the penalty, so giving that heads-up notice, and number two, providing the employer an opportunity to request a hearing before the LWD when the notice is issued. They have to do so, though, within 15 days of receipt in order to challenge these assessed penalties. So this is those 2 points in particular from the 2020 legislation I wanted to highlight. But again, this was sort of the cutting edge toolbox that the state was providing the LWD and enforcing this classification clearly at the impetus, at the urging of the Murphy administration. What I want to talk about just with the last few moments here that I have is the 2021 legislation, which is outlined on the next slide. And what this did was essentially enhance a lot of the tools that the LWD already had, particularly regarding stop work orders. But just before we get there, one additional point that the 2021 legislation gave beyond the stop work order enhancements was the ability for the Department of Labor, New Jersey Department of Labor, to seek a court injunction to prevent ongoing violations by employers. And in so doing, the commissioner of the Department of Labor would be entitled to collect attorney's fees and litigation costs if it should prevail. The law here, unlike we saw before with respect to the penalties that the Department of Labor could levy against an employer, where there was a series of factors it had to consider, here the law provides no series of factors that a commissioner must consider before deciding to pursue an enforcement action in court. It merely leaves such an analysis to the commissioner's, quote, sole discretion. So a little bit less clear what the commissioner would have to take into account, as it seeks a court injunction. With respect to the stop work orders, again, the 2020 legislation already gave the LWD the ability to issue stop work orders. Now, but previously it was focused under the law on issuing a stop work order for a specific place of business. Now the law went much farther, and it empowered the commissioner to issue a stop work order for one or more work sites or across all of an employer's work sites within the state when the employer commits just a single violation, which is pretty dramatic for employers to bear in mind, but also to hopefully no one sees these come across their desk. But should they do so, to realize that the LWD has the capacity and now the tools to issue such wide sweeping stop work orders. I'm just going to skip just to the third bullet point here, because during the stop work order, when it's in effect, the workers who are affected by such a stop work order are entitled to be paid by the employer for the first 10 days of work lost because of the stop work order, clearly supporting employees during the Murphy administration found that it wasn't their fault that the stop work order was issued, and that the employer should continue to pay them for at least 10 days when the stop work order causes the operations to shut down. the commissioner is allowed to actually bring legal action in order to ensure that these employees can collect on these unpaid wages for the first 10 days. And then finally, on this point, the commissioner may assess a civil penalty of $5,000 per day against an employer for each day that it conducts business operations in violation of one of these stop work orders. So a lot of penalties, a lot of dollar figures that we're talking about based on both the 2020 legislation and these 2021 enhancements that, again, just went into effect about a month ago. And then the last point was just the creation of a new office within the Department of Labor that's supposed to focus on enforcement and compliance of these misclassification laws. But I will leave it there and turn things over to Howie now.
Thank you, Daniel. I appreciate it. Now, the moment everyone's been waiting for, and I'm not talking about my presentation, I'm talking about the CLE code. The CLE code is S as in Seyfarth, then S as in Shaw, 2214. Again, that is SS for Seyfarth Shaw, 2214. So, thank you, Rob, Daniel, and Ephraim for your presentations. I think, there's a lot of us who've been dealing with COVID-related issues for the better part of, a year and a half at this point. Focus on those and, kind of day-to-day issues and haven't been able to kind of take a step back and see what's been going on in terms of laws that were kind of being passed, some quietly, some not, and also these important case decisions, which I think are very important for us to be mindful of. So, starting with Ephraim's presentation, I think it's, it speaks to the fact that employers in New Jersey need to be sure that their accommodation policies are robust enough and that it explains the process clearly, since the mere fact of not following through with the accommodation practice is now it's no longer a question whether it's an adverse employment action or not. So making sure that your policy explains what the process is, explains what needs to be done, what needs to be submitted to whom, and then making sure it's documented. Again, things that we've always viewed as a best practice are things now that courts, will be looking for, given that, a slip up could be deemed in and of itself an adverse employment action. So making sure that the policy is clear, unambiguous, and that employees receive a copy of it, and that you as an employer are able to demonstrate that an employee received a copy of it, so that you're not facing a lawsuit where an employee may say, well, I didn't know what the policy was, it wasn't available, or the policy changed, it wasn't disseminated. So definitely important for us to focus on. With respect to Rob's discussion, the arbitration issue is always been a hot button one, but I think, more and more of these decisions in New Jersey courts are coming out that yes, they're okay, even in spite of the legislation we talked about, but it's very important to make sure that it's specific enough to comply with Adelise and its progeny. And finally, with respect to Daniel's presentation, I think it's very important, given that those numbers add up quickly in terms of those penalties, to take a good hard look at your independent contractors in New Jersey to the extent you utilize them, making sure that you're comfortable with your agreements in terms of how the language is used and just the nature of the setup for how you have it set up and what factors you're using to determine whether someone is being treated and classified by your organization as an employee versus a contractor, given these penalties that are scary in terms of how they've been ever increasing. And again, from 2018 to now, there's been a tremendous amount of change in terms of the DOL's enforcement in New Jersey, and we're seeing it in our practice. So, all great discussion points and all things I think for us to not lose sight of and take into account. So with that, I want to leave some time for questions, but there's some few things I want to go through as part of our 2-minute warning. So next slide, please. So this legislation was proposed pre-pandemic, along with focusing on the independent contractor issue. Governor Murphy set a task force up to assess the state's anti-harassment, anti-discrimination laws, to take a look at whether the law was robust enough. And a task force came out with a pretty comprehensive report setting forth ways in which they believe the law should be changed. Right after that task force came out, there was legislation proposed that, was stalled for a while, but now we're seeing moving again to update New Jersey, the LAD. So for the hostile work environment, somewhat codifying the Rios case that Rob talked about, making it clear that a single incident can create a hostile work environment. Again, focusing on the fact that it's severe or pervasive, not both. The big one for employers is, anti-harassment training and policy requirements. So some states that employers operate, especially, for those who have operations in New York, are now aware that there's mandatory harassment training and policy requirements that have been in effect for a couple of years now. That's on the horizon for New Jersey. It's part of this proposed legislation, which has stalled, but I think, it's not stalled forever. I think there has been some activity as recently as June in terms of moving its way through the various steps in the legislature. So I would imagine that maybe when we're doing this presentation, later this year or early next year, we're talking about this legislation either being passed or pretty close to it, which would mandate anti-discrimination harassment policy, require the adoption of a written policy, require training. The New Jersey statute is written currently would require both training for everyone as well as special training for supervisors that focuses on their responsibilities as supervisors. There would be some reporting requirements that employers would have to annually report to the DCR regarding internal complaints of harassment, discrimination that are received, and as well as the outcome of those complaints, whether they were validated or not, and what action was taken or not. They're also, part of that legislation would increase the statute of limitations from LAD claims from 2 to 3 years and expand the protection of the law, not just to employees, but to domestic workers, interns, contractors, and pretty much anyone. So again, a pretty robust statute, which if it makes its way through the legislature and is signed in its current form, would drastically change the LAD in terms of employer requirements with respect to having policies to address these issues and training your employees. Next slide, please. Another law that, a lot of states and cities have been following are predictive scheduling laws. These are laws that were passed in order to help give employees in certain jurisdictions, predictability with their schedule. New York City has the Fair Workweek law, which applies just to retail employers as well as fast food employers. Other states and municipalities, Philadelphia, Chicago, Seattle, have similar laws. So New Jersey, there is a pending piece of legislation that would apply to mercantile, hospitality, restaurant, and warehouse establishments with 250 or more employees. There hasn't been much activity on this since it was introduced, but again, it was introduced pre-pandemic, so it's one of those pieces of legislation that we wouldn't be surprised if we see some activity on coming forward. It would put in parameters for employers to give employees schedules with predictability, having to give notice of schedules with a certain period of time, notice of any changes made to schedules, and then potentially premium payments if employers make changes to the schedule within a certain period of time. So, these are statutes that we're seeing still make its way across the country and that were stalled for a bit, but we do see a comeback. So I think it's something that it's worth monitoring for those employers with operations in New Jersey who may not be familiar with these laws in other areas they practice. Next slide, please. A few years ago, New Jersey increased the minimum wage. So for those of you, again, who have not been paying attention, hopefully by now, to the extent you're paying minimum wage to your employees, it is $12 in New Jersey as of January 1st of this year, scheduled to increase to $13 as it progresses towards $15 an hour. There are sub-minimum wages for tipped employees, smaller employers, agricultural employers, for those employers who have the workplace posting and maybe take it upon themselves to put up your postings rather than use a service that sends you the new one each year. There is an updated poster on the New Jersey DOL website, so you should download the new poster with the current minimum wages that was released by the Department of Labor. Next slide, please. And the last, but definitely not least, is the New Jersey WARN Act. We've discussed this piece of legislation at a few of our recent New Jersey webinars. It's one of, if not the most robust WARN laws that a state will have. The amendments that were part of this law, which has been signed into law, includes mandatory severance for layoffs of 50 or more within a 30-day period, as well as changes of definitions of employers, who's covered, and notice requirements. It was scheduled to go into effect in July of 2020, but then was paused by the governor. And right now it's still kind of held up There was some discussion that maybe it was going to be effective in October based on the way that it was paused, was tied to a certain executive orders. But at this point, there's no sign of that changing. So for right now, it's still on the sidelines, but when it's put into effect, it's definitely something that employers who are contemplating taking an employment action, laying people off, has to be mindful of. So next slide. And with that, we've wrapped up the substantive portion of our presentation. I think one question came in that I know Ephraim was going to tackle, but to the extent folks on the line have questions, please don't hesitate to type them in the box and we'll try to respond within the remaining few minutes that we have together.
Sure, thank you, Howie. And someone chimed in, I think, with a pretty great question, which is whether or not it's a violation of the LAD to deny to be denied applying for a job if the applicant needs to work remotely to fulfill family caregiving needs. The short answer here is that yes, there's potential exposure, but for a different reason than you may believe. Under the LAD, the protections run toward the employee themselves. So the employer's obligation is to provide a reasonable accommodation to that employee. It doesn't necessarily extend to disabled family members, spouses, or other individuals within their household or relationship. Now, with that being said, that doesn't mean that there isn't potential exposure here for what's called an associational disability claim. I've actually litigated these claims, and the LAD is silent on this specific issue, but there is conflicting case law that suggests that there is protection for an associational disability claim. There are specific statutes under the ADA that establishes this claim, and also the ADA itself clearly states that you're not under an obligation to accommodate a disabled family member for an employee rather. So there may not be a risk in terms of the accommodation piece, but there certainly could be a risk on the associational disability side of things if perhaps a person was not hired for a position simply because they're associated with a person that the employer perceives as being disabled. And there's a certain rubric that courts like to look at, that there's a very key Third Circuit case on that courts use to sort of arrive at the inference of discrimination there. That doesn't necessarily end the analysis there. It's not a topic here for this particular presentation, but it doesn't remove also the responsibility for the employer to potentially discuss other benefits for the employee, in particular leave, especially within this COVID environment. This individual may need time off to care for a family member who's convalescing from COVID or dealing with long COVID symptoms. There are certainly protections for those individuals. Additionally, under the FMLA and the FLA under New Jersey state law, there are protections for caring for an individual in your home that has a serious health issue. So no, not necessarily an accommodation issue, but you have to be wary of a potential associational disability claim. They come, they're litigated, and it is an exposure risk for employers. And alternatively, you need to work through the potential leave options for that particular employee if indeed they do need to take time off or need some sort of intermittent leave to care for a family member.
Thanks, Ephraim. And one additional point, just kind of piggybacking on that, and something that a lot of us are dealing with, is the fact that whether it's the LAD or some other New Jersey statute, whether it's independent contractor or even arbitration issues, so really anything, a lot of employers with operations everywhere, including those in New Jersey, have allowed people to work remotely and planning on continuing to doing so. So there are cases in New Jersey. I know Rob and I did a discussion about one of them, the Trevejo case from a few years ago, about the extraterritoriality reach of New Jersey laws. So you have an employee who's not working in New Jersey as a contractor or an employee, but arguably they're protected by New Jersey's laws. So I think it's also a good thing for employers who are allowing that, both related to COVID or going forward, to be mindful of the fact that if you're allowing someone to work elsewhere, they still may be covered under the New Jersey laws that governed as if they were an employee sitting in an office within the state. So, and that goes for really anywhere across the country. And that's something I know myself, and as I'm sure the other panelists are all dealing with as well, given that employers are trying to get back to what the kind of new normal is, and where people are going to be performing their job, going forward.
And Howie, just to build on that, I think you really raise a really great point. Any employer that is located within New Jersey but has employees outside of New Jersey, and any employer that is outside of New Jersey that has employees in New Jersey, the analysis has really changed and has really become a lot more of a focal point ever since the pandemic and everybody working from home. So I think now more than ever, these multi-jurisdictional and cross-border issues have really come onto the forefront.
Thanks. And with that, we are at 2:15. So if anyone does have any further questions, I believe you could still send us a note. But thank you everyone for your time today. We hope everyone stays safe. Enjoy the rest of your summer. Be well, and we look forward to seeing everyone again soon, hopefully in person. Be well, everybody. Thank you.